So I think we'll all benefit from this presentation. And over to you, madam. Thank you.
Okay. Thank you, Gihan, for, for that kind introduction. I will, I got a Zoom training by Sumudu, but I'm technologically challenged, so I will try my best.
Okay.
I'll try to share my screen with you now. Have I managed to do it or not?
No, madam.
We can't.
You can't see anything.
No, madam. It's the whiteboard.
Okay. Okay. Let's try again.
Madam, select the white presentation, not the whiteboard.
Yeah, wait. That's what I'm trying to do. Nope.
Madam, have you opened the presentation and minimized it?
Yeah,
Okay.
I have.
So then green button.
No? Any luck?
Yeah, we can see the presentation if you can maximize it.
Yeah. Okay.
Ah,
Can
yes,
you
that's
see
fine.
now?
Yeah, we can see now. Yeah. Now
Okay.
you can put it on the full screen. Yeah.
Okay.
Yes.
Yeah, that's fine. Yeah.
Okay. So I thought I will talk about the rights because I don't think anybody knows about the rights of intellectually disabled people. Is anyone aware of the legal situation in Sri Lanka at all? Yes or no?
There may be some child psychiatrists in the audience.
Okay. So I would like people to respond if they can, because otherwise I'm going to just go on talking. So what I'm going to do today is bring up some issues about why people with intellectual disability should have rights and how we can deal with it, because I think many people just pass them over and think, okay, we can deal with it because it doesn't really matter, right? So intellectual disability, as you all know, is a developmental disorder. And there are two issues which are a problem. One is that there are deficits in intellectual capacity. And the other one is that they have problems with adaptive functioning. And when I say adaptive functioning, it means that they have problems with the day-to-day life. Things like dressing, looking after themselves, basic things that we take for granted, they have problems with. So that is what intellectual disability is. So in DSM-4, it was called mental retardation, which carried a lot of stigma, right? And therefore now we have this term intellectual disability. The ICD-10 calls it disorders of intellectual development. So here we are. So all of you would have seen this graph, right? This is a very common one. And you know that the normal intelligence is between 85 and 115, right? And between 70 and 85, we say people are of borderline intelligence. And below 70, we say people are intellectually disabled. And according to the degree, we say it whether it's mild, moderate, severe, or profound. But these margins are really blurred, okay? Although we say that 55 to 70 is mild and 35 to 40 is moderate, it doesn't really, I mean, somebody who is 50 can be better trained than an untrained 65 person with 65 IQ. So the margins are very, very blurred. So as I told you, adaptive functioning is communication, participation in social activities, independent living skills, all that. And the onset has to be below 18 years, because if it's over 18 years, it's either acquired brain injury or later on in life, it becomes dementia. Okay. So one of the key issues in intellectual disability is the issue of consent, right? And we are going to look at, I wanted to look at consent for what is consent first. Understand, in order to see whether the intellectually disabled have ability to consent, you must know what consent is. So consent for treatment is when any healthcare professional, whether it's a doctor or any other professional, explains to you what they're going to provide you with, what sort of treatment they're going to provide you with. And it can be any tests that they're going to do, any medicines that they're going to do, right? And then you agree to having those tests or medicines or treatments, right? But before you give consent, you have to make sure that the doctor or the healthcare professional actually explains each of these things to you. Why are they going to do all these tests on you? What is the reason? And why are they going to give these medications to you? And do these medications have any side effects? And if so, what are the side effects? Right. And if you have to have any other procedures, they have to say what are going to be the advantages and what is going to be the disadvantages of those procedures. Right? So then you have to look at whether consent is valid or not, right? We may be able to give consent, but is it valid? For consent to be valid, first of all, it has to be voluntary, right? You have to give consent without someone putting pressure on you to give consent. The pressure can be exerted by a family member or a friend or a staff member. So you have to, if it has to be voluntary, it has to be entirely voluntary, right? Then it has to be informed consent. Informed consent is when the relevant information is given to the person and then the person agrees, being aware of the risks and the benefits, saying, okay, I'm aware of all the risks and benefits and I'm giving consent, right? And then you have to, the third thing is, for the consent to be valid, the person who gives consent has to have capacity. And when we say capacity, what I mean is that the person has to be able to understand the information that you give and then process that information and be able to communicate it, right? So in order for a consent to be valid, The consent has to be voluntary, it has to be informed, and it has to be made with capacity. And now, when I was doing psychiatry in Sri Lanka, consent was obtained when patients were admitted to the ward, right? They were just given, the bed ticket was given to the patient, and the nurse would say, "Medana Sankaranta," right? And the person or relative would sign. And no information was given. I don't know whether it has changed at all now. Do you think it has changed? Can someone respond to me?
I don't think so, madam.
You don't think so. Right. You think it's still
the ECT, yes. For ECT, there's a special form, and we explain to them and get their consent. If the patient is not consenting, we get the closest relatives to, and the nurses and the doctors take a bit of trouble in explaining the pros and cons of ECT.
Okay.
But for anything else, it's taken for granted, the consent.
Okay, right, okay. So, okay. So when we talk about informed consent, that is consent given by a person who has a clear understanding of what it is, what they're giving consent to, right? And that is considered really important here. So for example, if a psychotic patient comes to you, and do you think that person has capacity to give consent? Really, no. Here in Australia or in any other Western country, if a psychotic person comes, you would think that the person does not have capacity to give informed consent, right? So then you have to take special measures, right? So now look at what the criteria that have to be fulfilled in order for a person to have the capacity to consent, right? So if they have to have capacity to consent, then they have to, first of all, understand that they have an illness, right? And then they have to understand that what the nature and the purpose of the treatment is, and what are the risks, as I told you, and what are the consequences if you don't have treatment, and then be able to make a decision about whether they accept it, and then they have to be able to convey the decision. Now, when you look at all this, do you think any of the intellectually disabled people will have the capacity to consent? Really, no, right? So when you look at all these things that have to be fulfilled, the intellectually disabled, even if they are mildly intellectually disabled, here we consider that they don't have capacity to give informed consent. The mildly intellectually disabled may be able to give some consent, but not informed consent, because they won't be able to understand and explain to another person why they have made this decision. Okay, so we start off on the premise here that they don't have the ability to give consent. So capacity and intellectual disability, I have a couple of slides, right? So, it depends on the degree of intellectual disability, as I told you earlier. If they are moderately, severely, or profoundly intellectually disabled, they definitely do not have the ability to give informed consent. But if they are mildly intellectually disabled, they will be able to give consent, but not informed consent. So there is a distinction between giving consent and giving informed consent, right? So, because if you ask an intellectually disabled person, are you willing to take this medication? They will nod their head, right? That is also consent, but it is definitely not informed consent, right? Because whatever you explain to them about what the medication is going to do to them, what the side effects are, and all that, they will not be able to understand that or convey it to another person. So it is not, so the mildly disabled will have some ability to give consent, but definitely not informed consent. So then we come to discrimination versus rights. So what is disability discrimination? So disability discrimination happens when a person with a disability is treated less fairly than another person, than a normal person, right? And this happens all the time, right? And because of that, they have to really fight for their rights, right? Now, one of the special things about intellectual disability is that they are very different from other disabilities. Say the deaf, the blind, and even the physically disabled, they actually have a voice. They can talk and say, look, I would like to do this. And this is these are my wishes. But the intellectually disabled often don't have a voice. So it is their family or their friends or someone else who has to advocate for them. So that is why they are different. They are handicapped in more than the other disabled groups because they have no voice. So, but remember that the intellectually disabled persons have the right to all the things that we have. They have to have economic stability, they have to have social stability, and a decent state of living. Now, the blind, the deaf, and the physically disabled will have a voice to ask for those. But the intellectually disabled will not have that ability, unfortunately. So it is up to the parents or other advocates who have to work for them. Now, I don't know whether people are aware of the Sri Lankan situation. Whereas the legal structure is concerned, I looked at some documentation. There is an act which came out in 1996. That is the only act that I am aware of. Because after I left, there are other things that have happened. But the act which came out in 1996 came out on the 24th of October, and it was gazetted at that time, right? And that was for the protection of the rights of persons with disabilities, all disabilities, right? Until then, there was no protection for the rights of persons with disabilities, unfortunately, right? And this process was started actually in 1989, when the Minister of Social Services appointed a National Council for coordinating the work of disability organizations, right? Then, so I'll go into the history of the act because it might interest you. So they appointed a subcommittee, and this was supported by a Swedish organization called SHIA, right? And all the people in the groups, different groups, the blind, the deaf, the physically disabled, as well as the mentally retarded, which were represented by mostly parents, were parts of this group, right? And then they submitted their issues to the ministry in 1994. And the provision, what happened was, after that, they established these things. One was they established a National Council for Persons with Disabilities, which was the body which said, okay, these people should have the right to education, the right to vocational training, and so on and so forth, right? And then the Secretariat for the second one, the National Secretariat, was the arm which actually implemented what was decided. And then the funds were provided, and they also registered all the NGOs so that everything would come under one umbrella, right? Now, the membership of the council, actually the chairman was the Minister of Social Services, the secretary was the secretary to that ministry, and then there were 20 people in the committee, and the 11 people came from the disabled groups, and the other 9 people came from members of parliament. So all this happened in 1996, but let's look at what was the significance of this act. The significance was that this was actually the first time that there was some understanding and about the struggle that these people were having. And it was actually quite a watershed in that struggle, and that they now did not have to depend on charity. They could now go legally and say, look, I have a right to this, I have a right to education, I have a right to vocational training, so on and so forth. Then there are another couple of things which have happened after I left, which I'm not sure of, but I thought I'd mention it to you because they are of interest. One is in 2007, Sri Lanka has signed the United Nations Convention on the Rights of People with Disabilities. And this had been, but unfortunately, it had taken almost 10 years for it to be ratified. It was ratified in 2016, although they signed it in 2007, it was ratified in 2016, right? And so it became legal only in 2016. Then there was another interesting phenomenon, and that was in 2017, right? There was a review to see whether anything had happened in Sri Lanka after the act was enforced. And they actually found that nothing much had happened, unfortunately. So this investigation was done by the Disability Organizations Joint Front, right? Which was an organization formed in 2001. And they found that nothing much had been happening. So they looked at the rights, civil rights, political rights, social, economic, all that. And they found that in the area of education and training, there's a huge void, that there were no special units for these people. There were no special teachers, and there were no special classes. Then the other thing was, even when they were in school, many of them were unable to learn because they couldn't communicate, right? And if they couldn't speak, there was no other way for them to, there was no sign language provided, there were no visual aids provided, so they could not communicate. So there was no education happening. And sometimes they found that these people couldn't even gain access to the classes because there was no disability access. So if a person with ID had a physical disability as well, they wouldn't be able to go to school. If a person with ID had, say, epilepsy, they wouldn't be accepted in school, right? So these were huge problems that they noticed even at that time. Then the lack of vocational training was another problem. There were no institutions and there were no trainers. And obviously there was no employment opportunities at all, right? Because usually in other countries, there is a small quota for people who are disabled. And some of the mildly intellectually disabled people here actually work. They earn a small wage. They are able to work. They do very routinized jobs like stacking shelves and things like that. They do it quite well. But I suppose in Sri Lanka, we can't expect that, but at least they have a right to education and vocational training. Then when it comes to health, they found that there were no preventative measures and the public were not educated about how to prevent mental retardation or intellectual disability. Then there weren't enough personnel for early intervention and rehabilitation. There were no speech therapists, occupational therapists, and physiotherapists. They were there, but they were quite inadequate. Then there were no residential training facilities for children with behavior disorders. And that was one of the reasons why I started the school in Nampitia, because there were so many children who were able to, but simply because of other health issues, they were being refused school. They were being told to, even when they were in special units in the school, they were told, look, you can't come to school because you are having fits. So I thought that was totally unfair, right? Then the other thing is, there is the lack of awareness among medical personnel about management of intellectual disability. I mean, it's not only in Sri Lanka, I think it's even widespread here. Very few people know that. And the stigma is huge, even here. So, so they also said that there was no advocates for them, and the issue of guardianship was brought up. They also mentioned that females with ID were at greater risk of sexual harassment and exploitation at home as well as outside. It happens at home as well, right? And if they lose their family, there's no security for them. Right? These are not issues which are only happening in Sri Lanka, by the way. These happened here as well. The last but not least, I found this I found online. There's something called a Disability Rights Bill, which has come up started in 2019 and ratified in 2021, right? Again, the Ministry of Social Welfare is in charge, and there are lots of supporting ministries, and they are supposed to look at marginalized communities, right? So if you are interested, I can send you these documents. I have put it down for as my references, and you can look it up. Now, why are all these things relevant to psychiatric practice? Let's look at that. So one of the things is that the prevalence of psychiatric disorders is much higher in patients with ID, right? And when the psychiatric disorders occur in these people, they are more difficult to diagnose, and they're also more severe, right? Why is that? Because they have vulnerable brains. And in the West, what has happened over the last 30 years is, the intellectually disabled used to be housed in large mental hospitals in the West, right? So when they were young, the children were put into these large mental hospitals. They lived all their life in the mental hospitals, and they died there. But about 30 years ago, when the community movement started, the hospitals were dismantled and all the patients were rehoused in the community, right? Now, what happened with that was, when they went out in the community, now they had to be looked after by the average GP, the psychiatrist, the physician, the surgeon. Whereas earlier, when they were in the large mental hospitals, there were special doctors who were aware of what was happening, who would go and see them within the hospitals. So things have changed. So because of that, everyone has to be more aware. And why should you know about it? Because the training for both medical and psychiatric professionals about ID is quite insufficient. Right? And this also creates a barrier to proper intervention. Right? There's a study done by the Werner and colleague. They said 90% of the psychiatrists felt that they lacked specific training to diagnose and treat problems in the ID population. Right? We will come to that later in question time, right? So the prevalence of psychiatric disorders in people with ID, all psychiatric disorders, if you look at it, the 32 to 40% suffer from psychiatric disorders, right? And again, as I told you, the diagnosis of psychiatric disorders is more difficult. They are much more easily diagnosed in the mild intellectually disabled because obviously they are verbal and they can tell you how they feel. But when it comes to moderate, severe, and profound, diagnosis becomes very difficult. But as you understand, the illnesses are more common among them as well. So what are the comorbid psychiatric disorders that you see in patients with ID commonly? One is autism spectrum disorder, very common. ADHD, very common. Schizophrenia and other psychotic disorders, major depressive disorder, and all the anxiety disorders, all those things you get. But here are the percentages that you see. Now, ASD in a person in a group of mild ID, about 5 to 10%. But if you look at the moderate to severe ID group, the chances of them having ASD goes up to 30%. Right? In the average population, ADHD, the prevalence is 5%. Whereas in the ID population, it goes up between 8.7 to 60. Major depressive disorder is also almost twice, right? So all the disorders are higher, as you can see. So what are the challenges to the diagnosis of these people? The main challenge is the communication barrier that we have, right? When they're non-verbal, it is extremely difficult to diagnose. Even in verbal people, sometimes we have problems. So you can imagine what it is like when they are non-verbal. Then there are atypical presentations, right? And then of course, we can't use any tools. You can't ask them to do a questionnaire, right? And it's very difficult. So you have to obtain a lot of information from families or whoever brings them and observe their behavior, sometimes in many situations, in order to come to a diagnosis. Here, what I do now in my practice is, when I see people, I get information from the family or whoever the caregivers are. And then if they are in school, I go to school and do a school observation. And if they are in a home, I go and do a home observation as well. And if I can't go, another member of the team will go and make an observation at home. And then we all get together and decide, okay, what is it? So it's a fairly elaborate procedure, which I know cannot happen in Sri Lanka, but I'm just informing you what is going on here, right? So when you look at, okay, where does it leave us? So we come back to the full circle to issues regarding patients with ID. Do they actually have capacity to give consent or not, right? And are they able to give informed consent? Are they able to advocate for themselves? And as I told you, the mildly intellectually disabled have some capacity to give consent, but no capacity to give informed consent. and they are unable to, even the mildly intellectually disabled are unable to advocate for themselves. So what can we do? So one of the things that can be done is to appoint advocates to support people in making decisions. Now, what we found is when we tried to appoint advocates to support these people, we found that even with advocates trying to explain, even the mild intellectually disabled could not make decisions. The advocates were actually useful in the group who had an IQ between 70 and 85, 70 and 90, the borderline IQ people. They did better with the advocates. So what we do is we appoint legal guardians. That is, it can be a family member or there is a public guardian who will make decisions. So sometimes they need decision making in the area of legal matters, health matters, finances, and sometimes you have to decide who's going to do that. Sometimes even here, families say, look, we don't want to take on guardianship, and therefore then you have to go to the public guardian. And so when you look at treating these people, you have to then look at, okay, do we need a legal framework to treat them? Treat people with ID who have a mental illness. Here we are unable to treat them without putting them under the Mental Health Act. We have to, because they can't give consent, informed consent, we invariably have to put them under the Act in order to treat them. Unless they have a guardian. If they have a guardian, then the guardian can give consent to all the things I said earlier, except for ECT. Except for ECT, the guardian can give consent to treat them. But for ECT, if a person with intellectual disability requires ECT, we have to anyway put them under the Mental Health Act. So these are the references I have, and I will send them to you so that you can, and I will send the slides to you as well so that you can have a look at it. Any questions? Any clarifications, questions that you have?
Thank you very much, madam. I am sure there will be 62 participants participating, and we had a few child psychiatrists like eminent child psychiatrists like Professor Hemali Pera and Dr. Udayan Artigala, and so I'm sure there will be some questions for you. Yeah, it's open for discussion. So please ask your questions or type them in the chat so that we can ask Dr. Priyanka Ratnaik. I think, madam, a common scenario that we see in Sri Lanka is now it's mainly regarding the adults with learning disability because of the property issues that yeah, now that is a very common problem. I think all of us, all psychiatrists working in Sri Lanka may have come across that, faced that problem, and we are being called to the courts to say that yeah, this person has they have taken the signature by force without explaining them, and their property has been transferred onto the name of their siblings or whoever. And now when the parents die, they find that they have nowhere to go to because there's no house for them to stay, because no home, because the home is on the name of the sibling who is married, having children, and they are sent out. And this is a very common scenario. Yeah, and then only they come to us through some guardian or whoever and say that he has nowhere to go to because his home has been written on somebody else's name and no property at all, no income, no employment. So this is a very common problem in Sri Lanka where we have to struggle to get them some place to live. And
So
sometimes
what
it's
do you
very
do?
difficult. We of course do social services, we liaise with the social worker and try to get the help of the social services department and try to safeguard them, I mean, at the courts, but sometimes we fail. I'm sure the child psychiatrist will have more information about this. Udena, are you there? Or any other adult psychiatrist who has faced similar situations? Yeah, can you please tell us what is possible to be done in Sri Lanka in a situation like this? How you have managed it? Or a forensic psychiatrist? I think Dr. Susita Mendis was connected. Susita, are you there?
Hello?
Is it? Hello, yes, yeah. So, yes, Susita, I was just asking Madam Priyanratnayaka. Now, this is a common scenario that we have in Sri Lanka where we have been brought to our clinic some patients who are intellectually disabled and who have had properties on their name, but before or after the death of their parents, their properties have been transferred to their siblings without their knowledge because they have just obtained their signature without explaining to them what they are signing for. And as a forensic psychiatrist or as a general adult psychiatrist, have you had similar experiences, and what are we to do in such situations?
Actually, I haven't come across this situation in my practice as foreign psychiatrist. My understanding is that under our civil procedure code, the administrators, guardians, and what you call curators, managers can be appointed on behalf of unsound persons. There are provisions in one chapter to deal with people with unsound mind, and the mentally disabled people also come under this chapter in the civil procedure code. So there's a separate civil, procedural, and substantive law to deal with their properties and other important decisions. But there was one occasion that sometimes those people actually I don't get them in the state sector in the hospital, but sometimes we get one or two cases in the private sector in a situation where their properties have been bequeathed to somebody else without their knowledge. Like as you said, their signature has been obtained in surreptitious manners. But as a forensic psychiatrist, what I do see is that sometimes, not sometimes, I have to go to courts and testify with regard to their testimonial capacity. And they have become what we call, they have been victimized as children or adults of sexual offenses. And sometimes they are the only witnesses, what we call PASA community Sakshi number Anka. So they have to go to the courts and give their evidence. But when the case is going to be taken at the high court level, and generally they call reports for months. So in that occasion that we have to assess the patient for the testimonial capacity. Now the incident, the index offense, so the victimization has taken place about 10 years, so sometimes 15 years ago. And now the victim has to go to the court and give evidence. So yes, in that situation, it becomes very challenging because sometimes we don't have the family members of the person, and some of the people that we see are actually severely or sometimes profoundly mentally retarded. But with the people who are mild or mildly or moderately mental retarded, things are easy for us. Actually, what in my experience, most of the time courts set very low threshold when it comes to what we call testimonial capacity. Right? For other people, and usually the threshold is high, and so there are a number of components in the testimonial capacity, like person should be able to understand the question rationally, answer the question rationally, to understand what it entails to give evidence under an oath, and they should not be suggestible, and so on and so on. But my experience is that sometimes we have, as foreign psychiatrists, we have a kind of a advocacy role to play here as well. That is the most challenging thing for me, personally speaking. So sometimes the victim is mentally retarded and he or she is the only person, only witness to the crime. So now their testimonial capacity is definitely going to be challenged in the courts. So if we are going to say that the person does not have the capacity, so the prosecution would be left with no evidence to prosecute the perpetrator. So actually we cannot serve the justice. So I have seen that happening. So what I do is that sometimes I do not express the ultimate opinion and leave it open for the court to interpret. And I do talk about the functional abilities. What are the abilities they have in terms of testimonial capacity, and to what extent, and leave it up to the court to make judgment, categorical judgment about whether they are competent or not. But what I have seen most of the time is that actually court, when we say that even when the person is moderately mentally retarded or severely mentally retarded and their abilities are very low, court tend to think that they have the capacity. So I'm personally speaking, I'm happy about that, because if the court do not decide that way, right, and justice is not going to be served for these people. Right, so that is why it is important. But most of the time, when the people who work in the peripheries, when you get this kind of people, it is very important to assess these people thoroughly and record everything in detail and maintain the record, because the case is going to be called in 10 years time. So if you haven't recorded things properly, and if you haven't subjected the person or victim to the proper psychiatric and IQ assessment and functional assessment and so on, you would have all this forensic psychiatrist. So if you have to go to the courts, or the case would be referred to forensic psychiatrist, and then we will have a difficult time in the court. Sometimes it is not practically possible to obtain the original examination findings from the original doctor, because he hasn't kept the records with him. So when you do when you know that, okay, this is there are medical legal things are involved in the case, medical legal implication, it is good to keep a record, personal record with you. You know that you have to keep everything in the hospital, and they keep the records in the hospital. But apart from that, it is good to at least maintain what we call book, where you write when did you get the patient, and what was the patient name, where was the patient living, that kind of a basic information. Then you can retrieve that information later on. Okay, and that is one thing. And the mental disease ordinance for mentally intellectual disabled person, in our law there is no distinction between the mentally ill people and the mentally retarded people when it comes to unsound mind. So all people can be treated under our mental health act, and especially as temporary patient, people with mental retardation can be admitted to NIMH Angod. For the rest of the hospitals, so our mental disease ordinance only covers mental hospital. The only mental hospital to date is Angod. But other hospitals, that they have a problem. Sometimes they ask me also, so how can we treat a person who is not able to compete? So you don't have to worry. When the statutory law do not apply, what is applicable is what we call the common law. So under common law principles, you can treat mentally retarded people in whatever the setting that you function. So that in that case, you have to do a proper capacity assessment. If you can't do it properly, if you are a psychiatrist, you are supposed to do it, right? So sometimes you might get a consultation from another doctor, maybe a medical ward, maybe a surgical ward, to asking you to do a proper capacity assessment. Then you do it, you record it. If the person do not have the capacity, right? But we can't go to the courts. We don't have that practice in Sri Lanka, all right? I haven't come across even a single case where hospital had to go to courts to get the court's order in order to enforce the medication or whatever. So what we do is that treat the person under common law. So in that scenario, what we have to do is to record the assessment properly and record that the person does not have the competence, and get a second opinion regarding the treatment and so on, and get the informed consent of the family. That is the best practice. In a recent case in UK, that's a very talked about case, a lot of case that was talked about a lot. And the court actually decided that there is no point to take each and every case to the court when the person cannot actually consent. So doctors have that capacity, and the best practice should be to, when the person doesn't have the capacity, determine that properly, following the due process, due pathway, and then get a second opinion, then get the consent from the family. When there are no conflicts in the family among the family members, there is no problem. But when there are conflicts, then of course you have to go to the courts. But most of the time, if you talk to the family and if you record it, and you can do it, and then you have to think in terms of the patient's best interest. If the case is not emergency or urgent situation, in case of emergency, you don't have to worry about anything, right? But if it is a routine thing, so we only have to talk about the patient's best interest and record it and treat the patient. So actually, we can manage most of the people with intellectual disabilities in the general hospital setting, not the mental hospital, without much problem. That's my understanding.
Thank you for that input. Yeah.
It is, but I understand. I mean, having worked there, I do understand why it has to be done like that. But here we are subjected to a lot of restraints and restrictions. Even when there are behavior disorders in intellectually disabled people, and we prescribe for them, and even when we prescribe an antipsychotic, there are agencies which will question us about why we are prescribing antipsychotics for behavior disorders. Is it a psychotic disorder? If it's not a psychotic disorder, why are you prescribing antipsychotics? So you have to prove that the person has a behavior management program and that is not working adequately, and therefore the person needs antipsychotics as well. So it's quite complicated doing that. And you cannot do anything without any guardianship or advocacy. Our hands are completely tied that way.
Yeah, actually, madam, these laws that actually tend to discriminate the people with mental retardation rather than enhancing their capacity. Actually, if you look at the provisions of the CRPD, what they say is that actually this kind of laws are prohibited. If you have ratified the CRPD, so you cannot have separate laws to deal with intellectually disabled person. So
no, I agree with that. But the thing is, if the person doesn't have capacity, if the family members are not the guardians, is it accepted by law that they can give consent?
No, madam. That if you don't have a statutory law, statutory law is stating that if you that there should be a guardian and guardian has to consent for the person, then you have to follow that procedure. And there are no statutory laws. What the court says is that you follow the best medical practice and you record the incapacity on the part of the person, and then the consent from the then the treat in the best interest of the patient. And at the same time, you have to talk to the family and get their consent as well. Even though that consent is not valid, you can't base your intervention totally on that. You have done the capacity assessment. You are acting on behalf of the patient's best interest. At the same time, you have to talk to the family and you have got their agreement as well.
Yeah. I'm not saying that the situation here is ideal, Sujita, right?
Yeah.
Here we come across a lot of barriers in trying to treat patients here. because of all the laws.
Yeah,
Right.
because of the laws. Yes. The purpose of the law
Sometimes
is to
patients are
enable.
disadvantaged
Yeah,
because of
yeah.
the laws.
So,
I agree with you about that.
Yeah, that happens. That happens because the purpose of the law, entire purpose of the law is to help the people get the treatment, and law is actually welfare oriented. But actually, what the law practically does is it posits a lot of practical and logistic hindrances that person are eventually deprived of the welfare that they need to get. That happens sometimes. We are lucky in patients in our country are lucky in that sense, but sometimes, but there is the other side also, because some of all the doctors and all the people are not doing their job properly, and sometimes there is a chance of people being exploited because we don't have proper laws. So generally speaking, most of the time, actually, we can act act on the best interest of the person because we don't have much laws.
Yeah, I agree. What about patients who require ECT? What about if an intellectually disabled person requires ECT? How do you go about that? Can the family give consent?
No. That is again, madam, in our mental disease ordinance, they do not especially talk about any treatment or including ECT. Actually, there are two sections for unsound person and the temporary patients. For unsound person, the only purpose is to contain them. They don't talk about treatment, but practically we do offer them treatment. And with regard to the temporary patients, actually they do not have the capacity, so we can give them the treatment for their benefit. So that the word treatment is generally stated. So
it covers ECT too.
Right, ECT as well, but even there, best practice, there are two doctors should be involved. That is the default legal provision. But Angoda, that doesn't happen. So when we see a patient as a temporary patient in the OPD, we get the family to sign the form, and the doctor sign the form, and another doctor do not see the patient and sign the form. So especially when we administer ECT, two doctors has to see the patient. Those do not have to be consultants, but it is better if they are consultants. So in other words, whenever you have to administer ECT in Angoda, it is best to get the opinion of second opinion from another consultant. So that practice is not there, Angoda. That is what is legally required as the minimum.
Okay. Yeah. All right. Okay.
Yeah, thank you very much, Susita. And any more questions to Dr. Ratnaika? The trainees or the child psychiatrist? Madam, what we find is now the previous question that I asked, when the parents die, and when we go to courts, what the judge or the magistrate or whoever is asking is, can this person live on his own? And the answer is no. Most of the time the answer is no. And ultimately it comes that sibling has to take care of him. And anyway, and then they ask, can he manage his finances, or can he maintain a household and all that? And again, the answer is no. And ultimately, the ownership goes to the sibling. And they have been asked by the courts to take care of this intellectually disabled. And we don't know to what extent this happens in practice.
Does social services give them any remuneration for that? Any financial support if they are looking after someone? No. Okay.
Not to my knowledge. I don't know whether others will disagree with me or whether they can come in.
Some people are entitled to get what we call disability element. That is about 5,000 per month. That's all we have.
Yeah. So for that, they had to wait in the waiting list, and it's quite a tedious process, isn't it? So,
yeah.
To apply
Nowadays,
for that,
actually,
and
they have that relevance as well because of lack of money funds.
But for a certain year, there's a certain designated number of people that they give this social allowance for, and it usually goes for physical disabilities like lack of a limb or inability to walk or talk or see, blind people. So they get the priority anyway.
That's because they have a voice again.
Yeah, they have a voice, and our people come at the at the end of the list.
Yeah.
So, but we sometimes manage to get them, and there are so many of our clients who are on this disability allowance, which is 5,000 rupees a month, which is not great, but something.
But it's something.
Yeah. So,
Okay. All right. Okay.
any other questions?
That's it.
you,
So placement of these adult LD patients, like who are with moderate to severe learning disabilities, it's very challenging to find a place in Sri Lanka.
Yeah,
Fine. Like I don't know the experience of the other consultants in this regard.
Same. So Shanika is from the Central Province, madam. Yeah, she's now working at Teldenia. And we have this problem of now when they are mentally ill or chronically mentally ill, we have some places like, let's say, Deltota or in Martale or whatever to send them. But in the admission criteria, as Shanika quite correctly mentioned, learning disability is an exclusion factor. So even Deltota or anywhere, any other rehabilitation, medium stay or long term, they don't take. So we don't have any place in Colombo, I don't know, not in the Central Province, where they take for rehabilitation or for long-term placements people with learning disabilities, not in the government sector, to my knowledge. I don't know whether they are saying.
Right, okay, thank you.
Yeah. What about Colombo or Western Province? Anybody? Is there any other place where they take in the government sector people with learning disabilities or intellectual disabilities for long-term placements, like for example 6 months or few years for vocational training? But I mean, madam, you may be aware that we have 2 centers in the Central Province where they have what you call vocational training centers, which are one in Wattegama called Wavinna, and Katavala in Ampitia.
Both places were there when I was there.
Yeah, they are old and they are quite. They are residential vocational training centers where they keep them for 6 months, and they are quite good. According to their learning disability, they keep them for 6 months and give them some kind of vocational training like welding or carpentry or batik or something like that.
So still only those 2 places are available. Nothing new has come.
Yes. Nothing new. No, it's but Colombo may have. So so I think there are more opportunities or facilities in Colombo than the Central Province.
I think there's a lot of advocacy is needed too. If anyone is interested in this area, this is I don't think this is the ideal time to advocate for any money now in Sri Lanka, but in the future, I think it is an area which needs advocacy quite a bit.
And private centers maybe again in Western Province, but again not in the Central Province. So it's very unfortunate because there are some people who are willing to pay and to keep them, especially when their parents pass away, and but still we don't have any place to send them. Okay, then shall we make it today?
Yeah. Thank you very much for listening.
Thank you very much, madam. Because on a Sunday afternoon, with all these calamities in the country going on and the restrictions and having to stay in petrol and the gas queues, there were 62 participants for your presentation. And it was, I think, a very enlightening one, because although children, we can always refer them to a child psychiatrist and wash your hands off. But when they become adults, we have to deal with them. We have nowhere to send them. So I think your presentation gave us some insight into their rights of people of intellectual disabilities. And I think as clinicians, as trainees in psychiatry, I think it's quite beneficial to all of us to know the rights of our clients with learning disabilities, the legal rights. And that I think is very important to us. And we can't learn them from textbooks or in the internet. I think your references that you mentioned, if you can send them to us, it will be very interesting, very important. And also for the trainees, for their exam purposes, to know about the rights of the intellectually disabled. So thank you very much again for sacrificing your Sunday evening for our college lecture series. And thanks a lot. I think all of us benefited, not only the trainees, but the practicing psychiatrists and the adult psychiatrists mainly. The child psychiatrists may be already aware of this, but the majority who are adult psychiatrists probably are not that aware of the rights of the learning disabled. I think it was very useful. Thank you very much. Thanks a lot.
Okay, thank you, Gyan. Right, I'll send the slides to Sumudu. Is that okay?
Yes.
Yeah.
Yeah.
Okay.
Yeah.
Okay.
Thank
you very much.
Thank you very much.
Okay.
And thank you very much,
for the technical
Sumudu.
support, Sumudu.
Yeah. So
welcome,
Sumudu was,
Okay.
Sumudu, as usual, is the live wire behind all of these college lectures. Thank you very much, Sumudu.
Okay, thanks. Okay.